Perhaps we could start with the District Attorney's Office.
Thank you, Assemblymember Quirk and Senator Hancock and the committee members. On behalf of Los Angeles County District Attorney Jackie Lacey, thank you for inviting me here today to talk to you about the process that the Los Angeles County District Attorney utilizes in approaching the investigation, the prosecution of officer use of force and officer-involved shooting cases. I believe you have a flow chart that we prepared. I know it's in the handbook that was out in the audience today, but I believe you have a copy of it as well. And I just wanted to go through a little bit with you the process by which we review these cases as they come in. My position with the DA's office is the Assistant District Attorney over Special Operations and our Justice System Integrity Division. The division that actually prosecutes police officers is one of the 17 divisions in my operation. The division is made up of 15 very well-experienced prosecutors with an average of 12 to 15 years experience in the office before they even go to JSID. And if you don't mind, I'm going to use the acronym JSID. It's just easier than repeating Justice System Integrity Division 1,000 times. And JSID also has a dedicated group of 8 district attorney investigators plus a lieutenant and a captain from the DA's Bureau of Investigation that work with the prosecutors. About 15 years ago, the district attorney's office developed a protocol with the 52 police departments that operate within LA County to address officer-involved shootings by establishing an agreement that district attorney, deputy DAs and JSID, as well as our investigators, would roll out in real time, 24 hours a day, 365 days a year, when there's an officer-involved shooting. And we currently operate with 2 teams every day of the week, made up of 1 deputy DA that is, again, highly trained in this particular field, as well as 1 investigator. They will immediately get notified by law enforcement when there's an officer-involved shooting. It is extremely timely when they get notified, and they do roll out right to the crime scene during these particular incidents. So they are there. So you have a deputy DA from JSID with the investigator from the DA's office, a part of JSID, that are on scene, that are able to walk through the crime scene as police are still there, as well as interview civilian witnesses and also police officers with their voluntary statements. What I think a lot of members of the public don't necessarily appreciate is that by statute, the Penal Code 832.5, law enforcement is mandated to investigate themselves. So most police departments, I think all actually, have an internal affairs or some form of investigative unit within the police department to investigate the officer-involved shootings and instances of misconduct by police officers. We will do I don't want to say a parallel investigation, because our investigation commences at the point in time when we roll out, but we really do not pick up the full criminal investigation until after the law enforcement agency completes the entirety of its investigation. And that usually lasts somewhere between 6 to 8 months on average. Sometimes it could even be longer than that. Once the case is presented to the DA's office, at that stage, the JSID lawyers and investigators will work up the case almost anew. We may ask for additional follow-up. We may do our own follow-up. We oftentimes consult with use of force experts outside of the police department that was involved in the particular incident at hand. And then ultimately, we will evaluate the case and come to a conclusion as to whether or not, like any other criminal case that's presented to the LA County DA's office, a filing should take place. That's essentially the process.
Oh, okay. Is that the end of your testimony then?
I was told there were going to be some questions.
Oh, there'll be lots of questions, I assure you. I just wasn't sure. So if the other panel members could be similarly brief, well, I think there are going to be lots of questions here. Judge Cordell, could you speak? Thank you.
Thank you very much, and thank you for all for giving me the opportunity to speak with you this morning. I come to you with 19 years experience as a state court trial judge. I come to you with 5 years of experience as the independent police auditor for the city of San Jose, and I come to you with 65 years as an African American. I bring to you today, and I have written documents, copies for each of you, and you may not have them yet, 8 calls for action that, if implemented, will dramatically improve relationships between the police and communities of color, especially communities of color, and will dramatically promote unprecedented transparency in policing. And these 8 recommendations or calls to action are doable in our lifetimes if you have the political will. So what I want to do is briefly cover them, and I will not read this document, but I just want to hit the points if I can. Recommendation first is to require all police departments in California to collect data on all officer-involved shootings and establish a statewide nonpartisan office to maintain the data and to produce annual reports available to the public. And that data should include names, race, gender of officers and the victims, the outcomes, whether or not there were fatalities or injuries, and whether or not the victims were suffering from mental illness, whether or not they were armed, and if so, what types of weapons, along with other data. Second, require all police officers in California to periodically undergo crisis intervention training and establish a statewide CIT, crisis intervention training, best practices protocol. Frequently, and we've seen it in the papers, there are officer-involved shootings and uses of excessive force against individuals who are mentally ill, many of whom are unarmed. And as it stands today in California, police departments are not required to have their officers undergo any crisis intervention training. So you have some departments that do, you have some that do not. And the ones that do, most of them do not mandate the training. So officers volunteer to do it. I think that that should absolutely change, and that all officers should be mandated to take CIT. But as importantly, all of the various CIT trainings, there's no uniformity in them. Some are very good, some are god-awful. And what should happen is that there should be one uniform crisis intervention training using best practices. And to develop that training or that protocol, my suggestion is we should be using Prop 63 funds to make all of this happen. Next, require all police departments in California to equip their officers, patrol, SWAT teams, detectives with body-worn cameras, and as importantly, and maybe more importantly, develop a statewide uniform best practices protocol for the operation of body-worn cameras and ensure that that protocol is available to the public. Next, conduct a study to determine the best practices for the investigation of complaints from members of the public about bias-based policing. 2 startling facts. Since 2010, 5 years, in San Jose, the police department, there have been 203 allegations of bias-based policing against San Jose police officers from members of the public. The Internal Affairs Unit that investigates allegations of misconduct did not sustain none of the 203 allegations of bias-based policing. Add to that, Los Angeles Police Department received 204 allegations of bias-based policing just in 2013, and not one was sustained. Why is this? The method typically utilized by police departments to investigate, and I say that in quotes, these bias-based policing allegations is woefully inadequate. They are not investigations at all. It's basically 2-pronged. The officer is pulled into internal affairs and asked, did you stop that person, or did you do that because of that person's race? And the answer is always a resounding no. Then the investigation moves to the complainant, and the complainant is asked, what proof do you have that this was bias-based policing? And the complainant says, what proof? I don't have proof. I just know what happened to me, and I know how I felt. That's my perception. That's not an investigation. Recently, I spoke with Professor Jennifer Eberhardt, She's at Stanford University. She just was made a MacArthur Genius grant, given a MacArthur Genius grant. Her entire field of study is bias in policing. And I asked her, I said, what is the best way to investigate bias-based policing allegations? And her answer was, we don't know yet. We're working on it. This is a very new area. So it is my hope that this legislature would authorize a study to determine what is the best practice, because I know for a fact that the 407 people who made allegations of bias-based policing between San Jose and Los Angeles were not liars. They didn't make it up. Now, perceptions are neither right or wrong, but these were perceptions, and there needs to be a way to look into these so that we can determine what is legitimate and what is not. Next, require all police departments in California to collect data on detentions of pedestrians and drivers and establish a statewide nonpartisan office here to analyze the data. In San Jose, the police chief agreed, because of pressure from our office, to collect this kind of data starting January 1st, 2014. So we now have a year's worth of data. The problem is the police department will hire its own analysts and spend lots of money, and what do analysts do? They spin the data. They spin it, and that's what they do. And it's my view that that data is wasted if we allow it to be spun. And the best way to handle that is to have a nonpartisan state office that takes this data, looks at it, and figures out what indeed is happening. Next, require that independent prosecutors make decisions about whether or not to criminally prosecute police officers for officer-involved shootings and uses of excessive force, and prohibit the use of criminal grand juries in these kinds of cases. Right now, district attorneys make those decisions, and they have a very cozy relationship with the police officers. And that's, by definition, that's how they work. In my view, to establish trust with the community and transparency, when there is consideration of whether or not an officer should be criminally charged with often a shooting or excessive force, that decision should be made by independent prosecutors. You could utilize, for example, retired prosecutors, just like we utilize retired judges who occasionally sit by assignment and hear cases. And further, the criminal grand jury should not be utilized. It is secret. It is not adversarial. It is run solely by a prosecutor. In my view, to establish trust, there should be a preliminary examination, adversarial hearing where both sides are represented by counsel and it's available to the public. Next, require independent civilian oversight of all complaints of misconduct against police officers. In California, police departments, and cities can decide whether or not they want civilian oversight. So if we look at Santa Clara County, starting from the southernmost point in Gilroy and Morgan Hill, straight up to Palo Alto, there are only 2 police departments that have civilian oversight, San Jose and the city of Palo Alto. In my view, all police departments should be required, or all cities should be required, to have this independent civilian review. If not, we end up with the police policing themselves. There is no accountability. There is no transparency. And finally, require, and this is an easy one, require that all police departments in California make their duty manuals, or whatever they call them, their book of rules, available to the public. Right now, the police department of San Jose is maybe one of 2 in the country that puts the duty manuals online. We, as members of the public and taxpayers, should know what are the rules that guide our police. What is the rule, for example, in Oakland or in Sacramento for recording police officers? In San Jose, I can tell you because I can look it up on the duty manual, and the rule is any member of the public can record any police officer with any recording device as long as it's in public and you do not interfere. I don't know what the rule is in these other cities, and that to me is a shame. Taxpayers pay the salaries of police officers and paid for these duty manuals, and they should be made available to the public. Thank you.
Thank you very much, Judge Cordell. I think if we allowed applause, we would have had it after your impassioned speech. And I really appreciate that you're making such specific recommendations. I can't say what the legislature we'll decide to do about them, but to have a specific list like this is extremely helpful, and we'll see what happens. And again, I really want to thank you for being here and being so explicit. Mr. Bibrich.
Thank you, Assemblymember Quirk and committee members for the opportunity to address you this morning. My name is Peter Bibrich. I am the Director of Police Practice for the ACLU of California, and I'm going to be speaking today about issues of transparency, both in the context of investigations into law enforcement actions and a little bit beyond. Both some of the members of the committee in their introductory remarks and other witnesses this morning have recognized that transparency in government generally, and not just in law enforcement, is key to public trust. It's key to effective oversight and a sense that all people, all communities are in control of their government. And in fact, in California, we enshrine that in our Constitution, which provides that the people have the right of access to information concerning conduct of the people's business. And there is no business more important than policing. We provide officers with extraordinary authority to patrol our streets, to investigate, to detain individuals, to search our persons in our homes, and even to use force and to kill within the law. It is unquestionably the people's business to understand how that authority is exercised. But unfortunately, California is actually among the least transparent and the most secret of the states in the country when it comes to issues of officer discipline. And this is primarily due to the provisions of sections 832.7 and 832.8 of the Penal Code, the so-called PITCHS statutes, which are often confused with the Peace Officers' Bill of Rights, but are actually not part of that. Those provisions make confidential all personnel records of peace officers in California. That is defined to include not only obviously personal information like medical history, home addresses, the names of family members or contact information for family members, but also all records relating to evaluation and discipline. That provision has in fact been interpreted even more broadly by courts to bar disclosure not just of records of discipline, but records that could be used to assess discipline, such as internal investigations, civilian complaints, and other records related to use of force or investigations into misconduct that could be the basis for discipline. The result is that the public is deprived of basic information, not only about how individual officers have acted in certain high-profile incidents, but also how departments are responding to high-profile incidents, to issues of misconduct, to complaints of racial bias and other misconduct. And let me give you 4 examples of how this plays out, all of which I believe are ripe for reform. First, and Senator Leno touched on this in his earlier questions, sustained misconduct. Whether citizen complaints or internally generated investigations by other department personnel, if there is a finding of misconduct by an agency, a finding of excessive force, a finding of racial bias, that finding is confidential. The public, the press, cannot go to the department and find out whether a particular officer has sustained misconduct in his or her record, for any particular instance. That means not only in the situation where there's a high-profile incident, the public doesn't know whether there's a history of misconduct. It means that the public doesn't know if an agency is keeping around officers with long records of misconduct, and creates the general sense that agencies are hiding from the public whether their officers have a pattern of established misconduct. Now, I'm not talking about allegations of misconduct. I'm talking about actual findings. So a second context. High-profile incidents like shootings, other deadly uses of force. This is a situation where the names of officers are actually part of the public record. So if there is a high-profile shooting, whether it's Ezell Ford in Los Angeles or many other shootings or uses of force that are come to the public attention, the names of officers involved will be released. But the internal investigation into whether that use of force or fatality was within policy, if it's used as the basis of discipline, will not be public. It will be kept confidential. Obviously, many of these uses of force are known to the community, even without public records requests. They're in the headlines. People want to know what happened. Why was this in policy? Why was it not? Was the officer punished? Why or why not? And what has the department done to avoid future shootings? They're told, we can't tell you. It's confidential, just trust us. And that is not the recipe for community trust. Some departments do post summaries of investigations that are meant to be cleansed of information that is kept confidential, but those departments are few and far between. It's really only the larger departments, and those are by far the exception, not the rule. Now, these confidentiality rules were not such a problem as Senator Leno referenced before 2006, when the Supreme Court, in its Copley Press decision, gave strong indication that not only were the records of misconduct confidential, but also hearings arising from disciplinary appeals should also be kept confidential. Before that time, many jurisdictions allowed for the appeals from officer discipline or even the original hearings in civilian complaints to be held in public situations. So whether it's the State Personnel Board that reviewed CHP, appeals from CHP discipline, the Boards of Rights in Los Angeles, the County Civil Service Commission that reviewed appeals from discipline against deputy sheriffs all across the state, those were generally public. And that gave both the press and the public a window into how agencies were handling officer misconduct. After 2006, those hearings uniformly became closed across the state and really shut down public access to what is going on in the disciplinary system. Now, I mentioned earlier that California's laws are among the most secretive in the country. At least 10 states make records related to discipline public, regardless of disposition, whether the findings are that the officer engaged in misconduct, whether the findings are that the officer did not engage in misconduct. And those states they're all across the political map: Alabama, Connecticut, Georgia, Louisiana, Ohio, Washington State. This is not a partisan issue. This is not a red state, blue state issue. Similarly, at least 10 states make records public so long as there is a finding of misconduct. And those include states like Texas and Florida with large urban areas. And in fact, within California, this level of secrecy is unique to peace and custodial officers. For any other state employee, disciplinary records and even allegations of misconduct are public as long as the complaint is not trivial and there is reasonable cause to believe it is well-founded. Peace officers are given greater power by far than any state employee. The need for transparency is correspondingly greater. And it's worth calling attention that even private employees that occupy professions where they have tremendous authority, doctors and lawyers, have their disciplinary...
Okay, you've got about another 2 minutes.
Thank you. Have their disciplinary histories made public. So as a lawyer, you can go and I'm a lawyer. You can go and check my disciplinary history at the State Bar website. The same is true of doctors. You can check with the state board. And Judge Cordell has indicated that judges as well have their disciplinary history made public. And in fact, and there's a great deal of information already out there about peace officers. The counter-argument is the question that releasing this information could potentially pose a threat to officers, but there's simply no indication that that's the case. First of all, California law already makes the names of officers public. First of all, those involved in shootings. The California Penal Code requires that officers wear identifying information, their nameplate or badge numbers. And police must give their names when they testify in court against criminals. And in fact, there is data about the rate of assault on officers, and it doesn't correlate at all with police transparency. And in fact, to the extent it does, the rate of assault on officers is higher in jurisdictions that have less transparency than it is with more transparency. So these 4 areas of concern, And they're outlined in a fact sheet that we provided to the committee members. But sustained misconduct, high-profile incidents involving uses of deadly force, hearings, and one last area of civilian complaints. California law requires that civilians who file complaints be notified of the disposition of that complaint. But all too often, that notification consists of a simple, there was a charge sustained or there was no charge sustained. Any person who's had any experience complaining knows that if they are told simply, your charge was unfounded, we're not going to tell you why, we're not going to tell you what we found, that is unsatisfactory, and that is not building trust either in officers or the institutions meant to hold them accountable. The final step, my final comment, I just very briefly wanted to echo that data collection and reporting requirements are another form of transparency and one that is crucially needed. Data collection, both with respect to stop and frisk and also for use of force, is something that should be mandated, not only the collection, but also, as Judge Cordell referenced, the analysis. There need to be statewide standards for impartial analysis. And I will rest there.
Okay. Thank you very much. You've also, I got that? Yeah. Thank you very much, and I appreciate your very thorough answer to Senator Leno's earlier question. But I'd now like to go on to President Durant, and and I kept him for last so that he can respond to the various comments that have been brought up here. President Durant.
Thank you, Chairman Quirk, Chairman Hancock, and members of the committee. I'm honored to be here this morning to participate in this vital discussion and to make it clear that law enforcement intends to be a part of the solution. I understand completely the trust that is placed in an individual who carries a badge, the authority to assist in times of duress, and the power to arrest during moments of conflict can be found at the core of a safe and trusting society. This trust just be given, it must be earned and reinforced every time we meet with the members of our communities. My name is Michael Durant, and I have been in law enforcement since I first put on a badge more than 30 years ago. I am proud to be a deputy sheriff and have witnessed firsthand extraordinary service from the men and women in a range of capacities necessary to protect and serve the remarkable diverse communities within California. It can be argued that peace officers in California are the best educated and the best trained in the country. It can also be argued that while our jobs are rewarding, the challenges can also be extremely dangerous. 9 years ago, I was elected by my peers to be the vice president of PORAC, the Peace Officers Research Association of California, which was incorporated in 1953 as a professional federation of local, state, and federal law enforcement agencies. 2 years ago, I was unanimously elected as president and am pleased to represent more than 67,000 public safety officers throughout California and Nevada in over 915 associations, making PORAC the largest law enforcement organization in California and the largest statewide public safety organization in the nation. While I'm proud of the work law enforcement does in California on a daily basis, I also recognize that we can learn from the discussions here today, community forums, complaints, and concerns from individuals, and oversight that is an integral aspect of modern public safety. PORAC strongly believes that law enforcement must subscribe to 3 basic principles in the performance of our public safety responsibilities. Transparency. How we do our job is open to review. Accountability. No one is above the law, including us that wear the badge. And accessibility. The public has the right to ask questions, and we need to be here to answer them, and to answer them in a forthright manner that engenders the public trust. PORAC is willing to participate in these educational forums. We want the community to know we care, and we want to be a part of the solution. I have asked an expert on the investigation and prosecution of officer misconduct to join me today. With me today is Mr. Ed Fishman, who is the PORAC Legal Defense Administrator and at the forefront line of defending peace officers. Thank you both very much, and members of the committee.
You may go ahead.